Hello, and welcome to our comprehensive series on a topic that sits at the very heart of the United States tax system: compliance. Today, we begin our journey with an introduction to a set of pathways known formally as U.S. Voluntary Tax Disclosure Programs. Before we dive in, it is absolutely essential to state the following clearly. The information provided in this entire series is for educational and informational purposes only. It is not intended to be, and should not be taken as, legal, financial, or tax advice. The U.S. tax code is incredibly complex and individual circumstances vary greatly. You must consult with a qualified and licensed tax professional or attorney for advice tailored to your specific situation. This content is a general overview and does not create any kind of professional-client relationship. Now, with that crucial understanding in place, let's explore the fundamental question. What exactly is a voluntary disclosure program? Imagine the U.S. tax code as a vast and intricate map. For the most part, honest taxpayers navigate this map successfully year after year. But sometimes, people get lost. Mistakes can be made. An inheritance from a foreign relative might be overlooked. A small side business might have grown faster than the bookkeeping could keep up with. A complex investment might have been reported incorrectly. Or perhaps returns were simply not filed for a period of time. These situations can create a significant amount of stress and uncertainty. The fear of an audit, substantial penalties, or even more severe consequences can be overwhelming. This is where voluntary disclosure programs come into the picture. In the simplest terms, a voluntary disclosure program, or VDP, is an official legal pathway offered by the Internal Revenue Service, the IRS, and sometimes by state tax agencies, for taxpayers to come forward and correct past tax-related errors or omissions. The key word here is voluntary. It is a proactive step taken by the taxpayer to get right with the government before the government gets to them first. Think of it as a formal process for raising your hand and saying, "I've realized there's an issue with my past tax filings, and I want to fix it." It's a bridge designed to bring non-compliant taxpayers back into the fold. So, why do these programs exist? From the IRS's perspective, it's a matter of efficiency and encouraging widespread compliance. It is far more cost-effective for the government to have taxpayers come forward willingly than to spend vast resources on audits, investigations, and litigation to uncover every single error. These programs serve as a powerful incentive, encouraging people to clean up their own records, pay the taxes they owe, and become compliant taxpayers moving forward. It's a pragmatic approach to a complex problem. The core principle of any true voluntary disclosure is timeliness. To be eligible, a taxpayer must typically make the disclosure before the IRS has initiated any kind of civil or criminal examination. If you receive an audit letter or are otherwise notified that the IRS is looking into your specific tax affairs for a particular year, the window to make a voluntary disclosure for that issue has generally closed. The program is designed for those who come forward on their own accord, not as a reaction to being discovered. Now let's touch upon what is at stake. The risks associated with tax non-compliance can be significant. When the IRS uncovers errors on its own, it can impose a range of civil penalties. These can include accuracy-related penalties for underpayment, failure to file penalties, and failure to pay penalties. Interest will also be charged on any unpaid tax and penalties. In situations involving foreign accounts or assets, the penalties can be particularly steep. In more serious cases where the IRS believes the noncompliance was willful or fraudulent, the matter can escalate to a criminal investigation, which could potentially lead to severe consequences, including prosecution and imprisonment. This is the stick of tax enforcement. The Voluntary Disclosure Program, on the other hand, represents the carrot. By participating in a VDP, a taxpayer who has genuinely made a good faith effort to come forward and fully cooperate with the IRS may receive significant benefits. The most important potential benefit is that the IRS may agree not to recommend criminal prosecution. For many taxpayers, this is the primary motivation for entering the program. It provides a path to resolve a serious issue without the looming threat of a criminal case. Furthermore, while all back taxes, interest, and certain penalties must still be paid, the penalty structure within a VDP is often more predictable and can sometimes be less severe than if the non-compliance were discovered by the IRS during an audit. It offers a structured framework for calculating what is owed, providing a degree of certainty in what can otherwise be a very uncertain process. It is crucial to understand that a voluntary disclosure is not a simple matter of filing an amended tax return. It is a formal application process with specific procedures and requirements. The taxpayer is expected to provide detailed information, cooperate fully with the IRS examiner assigned to their case, and of course, make arrangements to pay the tax, interest, and penalties that are ultimately determined to be due. This process is not a get-out-of-jail-free card, nor is it an amnesty program that forgives all past obligations. Rather, it is a formal mechanism for resolution, a way to manage and mitigate the risks of past non-compliance and get a fresh start. Throughout this series, we will delve deeper into the different types of voluntary disclosure programs, including those focused on domestic tax issues, and those specifically designed for undisclosed offshore or foreign financial assets. We will discuss the general eligibility requirements, the steps typically involved in the process, and the critical role that an experienced tax professional plays in navigating this complex landscape. To summarize what we have covered in this first chapter, U.S. voluntary tax disclosure programs are official channels for taxpayers to proactively correct past filing errors and omissions. They exist to encourage compliance and offer a pathway to resolve tax issues with potentially reduced penalties, and most importantly, a potential safeguard against criminal prosecution. Participation is a serious and formal undertaking that requires full cooperation and payment of owed taxes. Thank you for joining us for this introduction. In our next chapter, we will begin to explore the key distinction between willful and non-willful conduct, a concept that is fundamental to understanding the potential consequences of tax non-compliance and the options available to taxpayers. Once again, please remember that this content is for informational purposes only. Always seek the guidance of a qualified professional for your specific tax and legal questions. Welcome back to our series on U.S. voluntary tax disclosure programs. In our first chapter, we introduced the concept of these programs as a formal pathway for taxpayers to correct past errors before the IRS fines them. Today, we delve into what is arguably the most critical distinction in this entire landscape: the difference between willful and non-willful conduct. As always, we must begin with our essential disclaimer. The information presented here is for educational purposes only and does not constitute legal or tax advice. The determination of willfulness is a complex legal matter based on the specific facts and circumstances of each case. It is imperative to consult with a qualified, independent tax professional or attorney who can analyze your situation and provide appropriate guidance. This discussion is a general overview of legal concepts and should not be used to self-assess your own conduct. So, why is this distinction between willful and non-willful so important? Because it fundamentally changes the stakes. It influences everything from the severity of potential penalties to the specific resolution programs a taxpayer might be eligible for, and most significantly, the risk of criminal investigation. Let's start with the concept that is easier to grasp: non-willful conduct. Generally, the IRS defines non-willful conduct as actions resulting from negligence, inadvertence, or a mistake. It can also include a good faith misunderstanding of the requirements of the law. Think of it as an honest error. For example, a person might inherit a modest bank account in a foreign country from a distant relative and be genuinely unaware of the separate, complex U.S. reporting requirements for such accounts, like the FBAR, or report of foreign bank and financial accounts. Another example could be a freelance graphic designer who miscategorizes a few expenses due to disorganized bookkeeping, leading to a small underpayment of tax. In these scenarios, there was no intent to deceive or defraud the government. The mistake was unintentional, while the tax, interest, and certain accuracy-related penalties would still be owed. The situation is viewed through a much different lens than one involving deliberate evasion. Now let's turn to the more serious category: willful conduct. In the context of tax law, willfulness is a legal term with a very specific meaning. The Supreme Court has defined it as a voluntary, intentional violation of a known legal duty. Let's break that down. Voluntary and intentional means it wasn't an accident. Known legal duty means the taxpayer was aware, or should have been aware, of their obligation under the law and chose to disregard it. Proving what a person was thinking, their intent, can be difficult. Because the IRS cannot read minds, it looks for external evidence or actions that suggest the taxpayer was acting willfully. These are sometimes referred to as badges of fraud or indicators of willfulness. While this is not an exhaustive list, some common examples of conduct that the IRS might view as evidence of willfulness include concealment, actively hiding income or assets, such as by using shell corporations with no real business purpose, or placing assets in the names of other people, offshore dealings, using financial institutions in jurisdictions known for bank secrecy, especially if combined with instructions not to send mail to a U.S. address, misleading statements, providing false or incomplete information to a tax return preparer, or lying to an IRS agent during an interview. Patterns of behavior. A consistent pattern of underreporting substantial amounts of income over several years is much harder to explain as a simple mistake compared to a one-time error. Handling of funds. Dealing extensively in cash for large transactions, cashing checks at check cashing services instead of depositing them into a business account, or keeping a double set of books, one for internal use and another false one to show the IRS. It is critical to note that a single one of these actions does not automatically prove willfulness. The IRS looks at the entire picture, the combination of facts and circumstances, to make a determination. There's also a related legal doctrine called willful blindness. This means a taxpayer cannot intentionally shield themselves from knowledge to avoid responsibility. For instance, a sophisticated investor who directs their financial advisor to set up an offshore structure for privacy, but then claims they intentionally avoided asking about any tax reporting requirements could be seen as willfully blind. The law can infer that the person chose to remain ignorant to avoid discovering their legal duties. The reason this distinction is the dividing line in tax compliance is because of the consequences. Non-willful failures, especially in the foreign account context, may be eligible for programs like the streamlined filing compliance procedures, which offer a more lenient penalty structure. Willful conduct, however, exposes a taxpayer to much more severe repercussions. This includes substantial civil fraud penalties, which can be as high as 75% of the unpaid tax, and a significantly increased risk of being referred for criminal investigation and prosecution by the Department of Justice. For a taxpayer whose conduct could be interpreted as willful, the main voluntary disclosure program is often the only viable path. Its primary benefit is providing a way to become compliant, and if fully cooperative, receive a recommendation against criminal prosecution. In summary, the line between non-willful and willful is the line between an honest mistake and intentional evasion. Non-willfulness is about negligence or inadvertence. Willfulness is about intentionally violating a known legal duty. The evidence of this intent is found in a taxpayer's actions and the overall pattern of their behavior. Making this determination is one of the first and most vital steps a taxpayer and their professional representative must carefully consider when addressing past non-compliance. Thank you for listening. In our next chapter, we will begin to look at the specific programs themselves, starting with the options available for taxpayers whose conduct is considered non-willful. As a final reminder, this information is for educational purposes. The application of these legal principles to any individual situation requires a detailed analysis by a qualified professional. Welcome back. In our last chapter, we established the critical difference between willful and non-willful tax non-compliance. We learned that intent is the dividing line that dictates the potential risks and resolutions available. Today, we focus on the pathways designed specifically for those whose conduct was non-willful. The IRS streamlined filing compliance procedures. Before proceeding, we must reiterate our foundational principle for this series. The information provided is for general educational purposes only and is not legal, financial, or tax advice. The streamlined procedures have very specific eligibility requirements and involve making legal certifications under penalty of perjury. It is absolutely essential to consult with a qualified and independent tax professional who can assess your personal situation before you consider any course of action. So, what are the streamlined filing compliance procedures? Think of them as a specific, modified channel created by the IRS to help taxpayers who are not intentionally avoiding their tax obligations. The primary goal of these procedures is to provide a less burdensome and more cost-effective way to get caught up on filing tax returns and reporting foreign financial assets. It's designed for the situations we described in the last chapter. Errors born from negligence, inadvertence, or a good faith misunderstanding of the law. The program is divided into two main tracks, based on where the taxpayer lives. First, there is the Streamlined Foreign Offshore Procedures, often abbreviated as SFOP. This track is for U.S. taxpayers, including U.S. citizens and green card holders, who reside outside of the United States. Second, there is the Streamlined Domestic Offshore Procedures, or SDOP. This track is for U.S. taxpayers who reside inside the United States. The most important gateway to either of these programs is the taxpayer's ability to certify that their previous failure to file returns or report income was non-willful. This isn't just a box to check. A taxpayer using these procedures must submit a detailed statement, signed under penalty of perjury, explaining the specific facts and reasons for their past compliance failures. This certification of non-willfulness is the cornerstone of the entire submission. The IRS takes this certification very seriously. If a taxpayer uses the streamlined procedures, but the IRS later examines their case and determines that their conduct was, in fact, willful, the taxpayer could be subject to much more severe civil penalties, and could even be referred for criminal investigation. This is why the decision to enter this program must be made carefully, and with professional guidance. Let's look at the general requirements for both tracks of the streamlined procedures. Typically, a taxpayer must file or amend tax returns. This usually involves the last 3 years for which the tax return due date has passed. The taxpayer must calculate and pay all the tax and interest owed with these returns. File delinquent information returns. This often includes filing the report of foreign bank and financial accounts, or FBR, for the last 6 years. It can also include other forms related to foreign assets, like forms for foreign trusts or corporations. The real incentive of the streamlined procedures lies in the penalty structure, which is where the two tracks differ significantly. For the streamlined foreign offshore procedures, SFOP, which is for taxpayers living abroad who meet a specific non-residency test, the benefits are substantial. If the IRS accepts the submission, all penalties related to the late filings and underpayment of tax are waived. Most importantly, the typically steep penalties for failing to file FBARs and other international information returns are also completely waived. The penalty is effectively zero. The taxpayer only owes the back taxes and interest. For the streamlined domestic offshore procedures, SDOP, for U.S. residents there is a penalty, but it is often far more favorable than what a taxpayer might otherwise face. Under the SDOP, the taxpayer pays a single, miscellaneous offshore penalty. This penalty is calculated as 5% of the highest aggregate year-end value of the taxpayer's foreign financial assets that were part of the disclosure. While 5% may sound significant, it's important to view it in context. Outside of this program, a taxpayer found to be non-compliant could face a multitude of penalties that could add up to a much higher amount. This can include failure to file penalties, failure to pay penalties, accuracy-related penalties, and information return penalties, including the FBR penalty, which for non-willful violations can be as high as $10,000 per account per year. The 5% penalty under the SDOP resolves these potential issues with a single, predictable calculation. As mentioned earlier, a critical component of any streamlined submission is the narrative, or the written statement of facts. This is where the taxpayer, often with the careful assistance of a tax professional, lays out their story. The narrative needs to explain their background, their ties to foreign countries, how they came to have foreign assets, and the specific reasons why they failed to meet their reporting and tax obligations. A vague or unconvincing narrative can lead to the submission being rejected. These procedures were created with certain taxpayer profiles in mind, such as individuals who inherited accounts and were simply unaware of the complex filing rules. U.S. citizens who have lived their entire lives abroad and didn't realize they had U.S. tax obligations, often called accidental Americans, or U.S. residents with foreign retirement accounts they mistakenly believed were not reportable. In conclusion, the streamlined filing compliance procedures are a vital tool, offering a structured and lenient pathway for non-willful taxpayers to come back into compliance. However, they are built on the bedrock of a truthful certification of non-willful conduct. In our next chapter, we will shift our focus to the other side of the compliance spectrum. We will discuss the main IRS voluntary disclosure practice, which is the primary option for taxpayers whose conduct may be considered willful. Thank you for joining us. We remind you one last time that this overview is for informational purposes only, and is not a substitute for professional legal and tax advice tailored to your specific circumstances. Welcome back to our series. In our previous chapters, we've explored the critical difference between willful and non-willful conduct and examined the streamlined procedures, the pathway for those who made unintentional errors. Today, we turn our attention to a much more formal and serious process, the IRS's primary voluntary disclosure practice, often referred to simply as the VDP. This chapter comes with our most important warning yet. The voluntary disclosure practice is designed for taxpayers who may have criminal exposure due to willful violations of tax law. This is not a do-it-yourself process. Navigating the VDP without representation by an experienced tax attorney is exceptionally risky. The information provided here is a high-level educational overview and is absolutely not a substitute for confidential legal advice from a qualified professional who can protect your rights. So, what is the voluntary disclosure practice? It is the long-standing policy of the IRS that allows taxpayers who have willfully failed to comply with their tax obligations to come forward, correct their records, and potentially avoid a recommendation for criminal prosecution. The key benefit, and the primary driver for entering this program, is to gain a level of certainty and closure on matters that could otherwise lead to a criminal investigation by IRS Criminal Investigation, or IRS-CI, and subsequent prosecution by the Department of Justice. This program is intended for individuals or businesses whose actions, as we discussed in Chapter 2, carry clear indicators of willfulness. This could include situations like the deliberate use of offshore accounts or complex structures to hide assets, intentionally failing to report significant amounts of business income over multiple years, or knowingly filing false tax returns. It is the designated path for those who cannot truthfully certify their conduct as non-willful. The VDP is a multi-step, rigorous process. Let's walk through a general overview of how it typically works. The first step is known as pre-clearance. Before a taxpayer reveals their identity and full story, their legal representative will typically submit a request to IRS Criminal Investigation. This request provides enough information for the IRS to check its own records. The purpose of pre-clearance is to determine if the taxpayer is even eligible to make a voluntary disclosure. Generally, to be eligible, the IRS must not already be aware of the taxpayer's non-compliance. If there is an existing civil audit, a criminal investigation, or if the IRS has received specific information about the taxpayer from an informant or other third party, it is usually too late to make a voluntary disclosure. If pre-clearance is granted, the taxpayer moves to the second step, preliminary acceptance. At this stage, the taxpayer, through their representative, must submit a more detailed application. IRS-CI reviews this information and, if it approves, provides preliminary acceptance into the practice. This is the formal green light to proceed with the full disclosure. The third and most intensive step is the full disclosure and civil examination. After preliminary acceptance, the case is assigned to a civil examiner from an appropriate IRS division. The taxpayer is then required to submit all necessary tax returns and information returns for the disclosure period, which is typically the most recent 6 years. This includes filing amended or delinquent income tax returns, as well as any required FBARs and other international information forms. Crucially, the taxpayer must cooperate fully with the IRS examiner. This means responding to information requests, providing documents, and answering questions throughout the examination. At the end of this process, the examiner will determine the final amount of tax, interest, and penalties due. This brings us to the penalty structure of the VDP, which is significantly more severe than that of the streamlined procedures. While the specifics can vary, the general framework includes full payment of tax and interest. The taxpayer must pay all back taxes and accrued interest for the entire 6-year disclosure period. Civil fraud penalty. In most cases, the IRS will assert a civil fraud penalty. This penalty is 75% of the unpaid tax, and it is typically applied to the 1 year within the disclosure period that had the highest tax liability. Willful FBR penalty. For undisclosed foreign accounts, the penalties for willful failure to file an FBR are substantial. The law provides for a penalty of up to 50% of the account's value for each year it was not reported. Within the VDP, the IRS may agree to a single, consolidated FBR penalty, but the amount is determined by the examiner and can be significant. Other penalties, such as those for failure to file or failure to pay, may also be asserted as applicable. The trade-off is clear. The financial cost of the VDP is high. The benefit, however, is invaluable. A path to resolve a serious criminal tax issue without a criminal prosecution. It provides finality and allows the taxpayer to move forward with a clean slate. It is impossible to overstate the importance of having a tax attorney in this process. Unlike an accountant or other tax preparer, communications with an attorney are protected by the attorney-client privilege. This privilege is vital in matters with potential criminal implications, as it allows for open and confidential discussion of all facts. An attorney is essential for navigating the complex procedures, communicating with IRS-CI, and advocating on the taxpayer's behalf during the civil examination. In summary, the voluntary disclosure practice is the definitive, formal process for taxpayers with willful noncompliance to come forward. It is an intensive, expensive, and legally complex journey, but it is the established mechanism to mitigate criminal exposure and achieve full compliance with the U.S. tax system. In our next chapter, we will place the two main pathways side by side, offering a direct comparison of the streamlined procedures and the voluntary disclosure practice to help clarify which path is designed for which situation. Thank you for listening. Please remember, this overview is purely for educational purposes and should not be considered legal or tax advice. Any taxpayer concerned about these issues must seek counsel from a qualified professional. Welcome back. Over the past 4 chapters, we have established the foundational concepts of tax compliance and introduced the 2 primary pathways the IRS offers for taxpayers to correct past mistakes: the streamlined filing compliance procedures and the main voluntary disclosure practice, or VDP. Today, we are going to place these 2 roads side by side for a direct comparison to crystallize their differences and clarify their distinct purposes. As always, we must begin with our essential disclaimer. This comparison is for general educational purposes only and does not constitute legal, financial, or tax advice. Choosing the correct path is a critical decision based on an individual's specific facts and circumstances. This decision must be made in consultation with a qualified tax professional who can provide advice tailored to your situation. Let's break down the comparison across 5 key areas. First, and most importantly, the target taxpayer. This is the fundamental dividing line. The streamlined procedures are exclusively for taxpayers whose past conduct was non-willful. As we've discussed, this means the errors were due to negligence, mistake, or a good faith misunderstanding of the law. The taxpayer must be able to truthfully sign a statement, under penalty of perjury, certifying their non-willfulness. In stark contrast, the Voluntary Disclosure Practice (VDP) is the designated pathway for taxpayers whose conduct could be interpreted by the IRS as willful. These are individuals who cannot sign the non-willful certification and are concerned about their potential exposure to criminal investigation. Think of this as the ultimate fork in the road. The facts of the case dictate which path is even an option. Second, the primary goal and level of protection. The primary goal of the streamlined procedures is to provide a straightforward way to get compliant while receiving significant penalty relief. It offers a favorable and predictable penalty outcome. However, it does not provide formal protection from a potential future criminal investigation if the IRS were to disagree with the taxpayer's claim of non-willfulness. The primary goal of the VDP is to manage and mitigate criminal risk. Its main benefit is providing the taxpayer with a high degree of confidence that upon successful completion of the program, the IRS will not recommend criminal prosecution to the Department of Justice. The VDP is about resolving the most serious potential consequences of non-compliance. Third, the process and degree of scrutiny. The process for the streamlined procedures is largely submission-based. The taxpayer and their representative prepare a package of tax returns, information returns, and the crucial narrative of non-willfulness. This package is sent to the IRS for processing. While the IRS can select any return for audit, the program is not designed as an automatic, full-scope examination. It is generally a less interactive process. The VDP, on the other hand, is a far more intensive and interactive engagement with the IRS. It begins with pre-clearance through IRS criminal investigation, followed by a formal application, and culminates in a full civil examination. Essentially, a comprehensive audit of the 6-year disclosure period. It requires ongoing cooperation with an assigned IRS examiner. Fourth, the financial cost and penalty structure. Here, the differences are dramatic. For the streamlined procedures, the financial outcome is designed to be corrective, not punitive. For taxpayers abroad in the foreign offshore program, the penalty is 0. For U.S. residents in the domestic offshore program, it's a flat 5% miscellaneous offshore penalty. Civil fraud penalties do not apply. The VDP is financially punitive by design. The penalty structure is severe to reflect the willful nature of the conduct. It typically involves a 75% civil fraud penalty on the year with the highest tax deficiency, in addition to other accuracy and filing penalties. For offshore issues, a separate and substantial willful FBR penalty will also be determined by the examiner. The total cost is significantly higher. Finally, our 5th point of comparison, the role of a professional. For the streamlined procedures, professional assistance from a tax attorney or a knowledgeable CPA is strongly recommended to ensure the submission is accurate and the non-willful narrative is properly crafted. For the VDP, representation by an experienced tax attorney is considered absolutely essential. Due to the inherent criminal risk, the protection of the attorney-client privilege is paramount. This privilege allows the taxpayer to have completely confidential communications with their lawyer, which is a critical safeguard not available with other types of preparers in a criminal context.
Disclaimer: this video is for informational and educational purposes only and should not be considered professional legal, financial, or tax advice. I am not a certified public accountant, CPA, or a tax attorney. You should consult with a qualified professional for advice tailored to your individual situation. Tax laws are complex and subject to change. The creator of this video or the channel will not be held liable for any actions taken based on the information provided.
To summarize the comparison, who is it for? Streamlined is for the non-willful. The VDP is for the willful. What is the goal? Streamlined seeks penalty relief. The VDP seeks to avoid criminal prosecution. What is the process? Streamlined is a submission. The VDP is a full examination. What is the cost? Streamlined has low or zero penalties. The VDP has high fraud and FBR penalties. These programs are not interchangeable. They are two different tools designed for two very different sets of circumstances. The choice is not based on which outcome a taxpayer prefers, but on which program fits the underlying facts of their case. In our next chapter, we will discuss a few other, more niche compliance options, such as the delinquent FBR submission procedures, for taxpayers with very specific and limited compliance issues. Thank you for joining us. We remind you once more that this comparative analysis is for educational purposes and is not a substitute for confidential, professional advice based on your personal situation. Welcome back. In our last chapter, we drew a clear line between the two primary highways to tax compliance: the streamlined procedures for non-willful conduct and the voluntary disclosure practice for willful conduct. Today, we move away from those main highways to explore a couple of smaller, more specialized paths. These are designed for taxpayers with very specific and limited compliance issues: the delinquent FBR submission procedures and the delinquent international information return submission procedures. As we navigate these specific topics, our standard disclaimer is more important than ever. The information provided here is for general educational purposes and is not a substitute for professional legal or tax advice. These niche procedures have very narrow eligibility criteria, and misusing them can lead to significant problems. Always consult a qualified professional to determine the correct course of action for your specific facts and circumstances. Let's first discuss the delinquent FBR submission procedures. To understand this, we need to be clear on what it is not. This is not a program for individuals who have unreported income from foreign accounts. If a foreign bank account earned interest, dividends, or other income that was not reported on a U.S. tax return, this procedure is the wrong path. So who is it for? This procedure is designed for a very specific type of taxpayer: a U.S. person who has been fully compliant with all of their income tax obligations, but simply failed to file the required report of foreign bank and financial accounts, or FBAR. The key conditions for using this procedure are: the taxpayer has no unreported income. They do not need to file an amended or delinquent tax return to report additional income or pay additional tax. The taxpayer has only recently learned of their obligation to file an FBAR and has a reasonable cause for the late filing. Essentially, this is a remedy for a reporting-only error. For example, consider a U.S. resident who is a signatory on a non-interest-bearing foreign account for an elderly parent, an account that held no income-producing assets. They were fully compliant on their tax return, but were unaware that simply having signature authority over that account triggered an FBAR filing requirement. The process itself is relatively straightforward. The taxpayer electronically files the delinquent FBARs for the required years. When filing, they must select a reason for filing late from a drop-down menu and include a statement that provides a reasonable cause for the delinquency. If the IRS reviews the submission and accepts the explanation of reasonable cause, it will not impose penalties for the late FBAR filings. This is a significant benefit, as FBAR penalties, even for non-willful violations, can be substantial. Now let's turn to a similar path: the delinquent international information return submission procedures. This is a parallel process for other specific international forms, beyond just the FBAR. These can include forms like Form 5471, for interests in certain foreign corporations, or Form 3520, which is used to report transactions with foreign trusts or the receipt of large foreign gifts. Just like the FBAR procedure, the core requirement is that the taxpayer has been fully compliant with their income tax obligations. There can be no unreported income or unpaid tax associated with the information on the delinquent form. The taxpayer must also be able to demonstrate that their failure to file the form on time was due to reasonable cause. The process here is slightly different. The taxpayer generally files the delinquent information return attached to an amended tax return. Even if the amended tax return itself shows no changes to income or tax liability, it serves as the vehicle for submitting the late form. Attached to this filing must be a statement of facts, signed under penalty of perjury, establishing the reasonable cause for the late submission. This brings us to the concept of reasonable cause. This is a legal standard that depends on all the facts and circumstances of a particular case. Generally, it means that the taxpayer exercised ordinary business care and prudence, but was still unable to file the return on time. A simple mistake or ignorance of the law is often not, by itself, considered reasonable cause. The determination is highly fact-specific, which is why a professional's analysis is so important. A crucial warning is in order for both of these procedures. Using them when there is unreported income is what the IRS sometimes calls a quiet disclosure. A quiet disclosure, simply filing amended returns or delinquent forms hoping the IRS doesn't notice the past noncompliance, is strongly advised against by the IRS and could result in a full examination and the imposition of all applicable penalties, including civil fraud, and in some cases, even a criminal investigation. In summary, the delinquent filing procedures are valuable, penalty-free options, but only for the small subset of taxpayers who have a clean income tax record and a valid, reasonable cause for their failure to file a specific form. They are for reporting errors, not income errors. We have now covered the main disclosure options available. In our next chapter, we will shift our focus from the what to the how, discussing the critical first steps a person should take when they realize they have a potential tax problem. Thank you for listening. We remind you once again, to seek confidential advice from a qualified tax professional regarding any of the topics discussed in this series. Welcome back. In our series so far, we have mapped out the various programs the IRS offers for taxpayers to correct past compliance issues. We've compared the pathways for willful and non-willful conduct and looked at niche procedures for specific errors. But today, we address the most personal and often the most stressful part of this entire journey: the moment of realization. What should you actually do when you discover you may have a tax problem? This chapter is designed to provide a general, educational framework for those first critical steps. It is not and cannot be a substitute for confidential, professional legal advice. The guidance provided here is for informational purposes only. Every situation is unique, and a qualified professional must be consulted to analyze your specific circumstances. So you've just realized something is wrong. Perhaps you learned about an FBAR filing requirement you never knew existed. Maybe you inherited a foreign asset and didn't report the income. Or perhaps you've received a notice from the IRS. The feeling can be overwhelming, but panic is not a strategy. The correct first steps are methodical and deliberate. Step 1. Do not ignore the problem. The single worst thing you can do is nothing. Tax problems do not disappear on their own. They tend to grow more complicated and more costly over time. Interest and penalties continue to accrue. The window of opportunity to make a voluntary disclosure can close at any moment if the IRS initiates an audit or investigation. Acknowledging the issue and deciding to address it is the most important first step you can take. Step 2. Resist the urge to immediately act on your own. Your second instinct might be to quickly file an amended tax return or a late FBAR on your own, hoping to fix things quietly. As we've mentioned before, this is known as a quiet disclosure. This is an extremely risky approach. Filing an amended return that shows significant changes without going through a formal disclosure program can act as a red flag, potentially inviting an audit or even a criminal investigation. Before you file anything, you need a clear strategy. Step 3. Gather your information, but do not create self-incriminating documents. Begin to mentally organize the facts. What is the nature of the issue? Which tax years are involved? What documents do you have? Bank statements, tax returns, correspondence. However, be very careful about what you write down. Do not create detailed timelines or analyses of your own conduct, especially if you believe your actions could be considered willful. These types of documents could potentially be obtained by the government in an investigation if not properly protected. This phase is about mental organization and locating existing records. Step 4, and this is the most critical: seek professional counsel. This is the point where you must engage a professional, but the type of professional you choose is vital. If there is any possibility that your conduct could be viewed as willful, or if the matter involves significant undeclared assets or income, the professional you consult should be a tax attorney. Why a tax attorney? The reason is something called the attorney-client privilege. This is a fundamental concept in U.S. law that protects confidential communications between a client and their lawyer for the purpose of seeking legal advice. This means you can speak with complete honesty to your attorney, revealing all the facts, both good and bad, and those communications are shielded from being disclosed to the IRS or any other party. This privilege generally does not exist in the same way with an accountant or CPA. While there is a limited tax practitioner privilege, it is not as broad as the attorney-client privilege, and most importantly, it does not apply in criminal tax matters. In a situation with potential criminal implications, a non-attorney could theoretically be compelled to testify against you. An experienced tax attorney can listen to your full story under the protection of privilege, and then provide a legal assessment of your situation. They can help you determine if your conduct was likely willful or non-willful, which is the key to choosing the correct disclosure path. If accounting work is needed to analyze financial records or prepare returns, the attorney can hire an accountant directly under what is known as a coval arrangement. In this structure, the accountant works for the attorney, and the attorney-client privilege can extend to cover the accountant's work, keeping the entire team's analysis confidential. In summary, your first steps are clear. Acknowledge the problem, don't take hasty actions, organize your thoughts, and most importantly, consult with a qualified tax attorney to ensure your rights are protected and you receive confidential, competent legal advice. In our next chapter, we'll discuss what you should look for when choosing the right tax professional to guide you through this process. Thank you for listening. This content is for educational purposes only, and is not a substitute for professional legal counsel. Welcome back. In our last chapter, we discussed the critical first steps to take upon discovering a tax problem, culminating in the decision to seek professional counsel. Today, we're going to expand on that crucial step. Once you've decided to get help, how do you choose the right professional for your specific and often sensitive situation? As we proceed, please remember our consistent and essential disclaimer. This information is for general educational purposes. It is not legal or financial advice, and does not constitute an endorsement of any particular professional or type of firm. The decision to hire a professional is a personal one that should be based on your own research and due diligence. Choosing a guide for this journey is one of the most important decisions you will make. The right professional not only provides technical expertise, but also offers peace of mind during a stressful time. Here are some key factors to consider. First, the right credentials and specialization. Not all tax professionals are equipped to handle complex voluntary disclosures. A general accountant or a preparer who primarily handles standard annual tax filings may not have the specific experience needed. As we discussed in the last chapter, if there is any concern of willfulness or potential criminal exposure, a tax attorney is the appropriate choice due to the protections of attorney-client privilege. Look for a professional, whether an attorney or for purely non-willful matters, a CPA or enrolled agent, who specializes in tax controversy and voluntary disclosures. Their website, professional biographies, and publications should reflect a deep focus in this specific area. This is a highly specialized field, and you want a specialist, not a generalist. Second, relevant experience. Experience is paramount. When considering a professional, you should feel comfortable asking about their experience with cases like yours. While they cannot discuss specific client details, they can speak in general terms about their work. You might ask questions like, how many voluntary disclosure cases have you handled? Do you have experience with both the streamlined procedures and the main VDP? Have you represented clients with undisclosed assets in the specific country or region relevant to my case? How do you interact with IRS criminal investigation and civil examiners? Their answers should give you a sense of their familiarity and comfort level with the landscape. An experienced professional will have a well-defined process and will be able to explain it to you clearly. Third, a clear fee structure and engagement letter. Before you formally hire anyone, you must understand how you will be billed for their services. Most tax attorneys and specialized professionals work on an hourly basis. They should be able to provide you with their hourly rates and an estimate of the total cost, often based on a range reflecting the potential complexity of the case. Be wary of anyone who promises a specific outcome or a flat fee that seems too good to be true. Once you decide to move forward, the relationship should be formalized with an engagement letter. This is a contract that outlines the scope of the work to be performed, the fee structure, billing practices, and the responsibilities of both the professional and you as the client. A clear engagement letter prevents misunderstandings down the road and is a hallmark of a professional operation. Fourth, professionalism and communication. During your initial consultation, pay attention to the professional's communication style. Do they listen carefully to your situation? Do they explain complex concepts in a way you can understand without using excessive jargon? Do they seem organized and methodical? This person will be your guide and advocate. You need to feel confident in their abilities and comfortable with their communication. They should be realistic about the potential outcomes and should not overpromise. A good advisor manages your expectations by providing a clear-eyed view of the process, the risks, and the potential results. In summary, choosing the right professional involves a thoughtful process. You are looking for a specialist with verifiable, relevant experience in tax controversy and disclosures. You need a clear understanding of their fees and a formal engagement letter. And finally, you need a trusted advisor who communicates clearly and professionally. Taking the time to find the right representative is an investment in the success of your case and in your own peace of mind. In our next chapter, we will begin to walk through the disclosure process itself, starting with the initial steps of a typical engagement with a tax professional. Thank you for listening. Please remember, this guidance is for informational purposes only and is not a substitute for conducting your own thorough search and consultation process. Welcome back. In our last chapter, we discussed the critical process of selecting the right tax professional to guide you. Now, let's assume you've made that choice and have formally hired a tax attorney to represent you. What happens next? This is where the real work begins. A deep dive into the facts of your case, known as the factual investigation and risk assessment. As we delve into this process, please remember our essential rule. This chapter describes a typical process for educational purposes only. It is not legal advice. The way your specific case is handled will be determined by your professional representative based on your unique circumstances and under the protection of attorney-client privilege. Once you sign an engagement letter, the first phase of your representative's work is to become an expert on your situation. They can't advise you on the best path forward until they know every relevant detail. This process is thorough, confidential, and absolutely critical. The comprehensive interview. It all starts with a comprehensive interview. Under the shield of attorney-client privilege, your lawyer will ask you to tell your story in its entirety. This is the time for complete honesty and transparency. You should expect to be asked detailed questions about your background, your personal history, education, profession, and level of financial sophistication, the assets or income in question. How did you acquire the foreign account? What is the nature of the unreported business income? When did the issue begin? Your knowledge and intent. What did you know about your tax and reporting obligations, and when did you know it? What were your reasons for not complying? Involvement of others. Did you rely on advice from a banker, an accountant, or another advisor? Were family members involved? Previous filings. Your tax filing history, including who prepared your returns and what information you provided to them. The goal here is for your attorney to see the situation from all angles and to understand the story behind the numbers. Document gathering and analysis. Alongside the interview process, your attorney will ask you to gather all relevant financial and legal documents. This isn't just a casual request, it's a systematic collection of evidence. This can include past tax returns filed in the U.S. and any other country, complete bank, brokerage, and investment statements for all accounts, both domestic and foreign, corporate documents, trust agreements, or partnership agreements if entities are involved, correspondence with financial institutions, accountants, or other advisors, personal records, such as inheritance documents or gift letters. Your legal team, possibly with the help of a forensic accountant working for the attorney, will meticulously review these records. They will create a financial roadmap, tracing the flow of money and calculating the unreported income and resulting tax deficiency for each year in question. The critical assessment. Willful or non-willful. This is the most important judgment call in the entire process. By combining the information from your interview with the evidence from your documents, your attorney will perform a risk assessment. They will analyze the facts through the lens of the IRS and the courts. They will look for those badges of fraud we discussed in Chapter 2, such as patterns of concealment, misleading statements, or dealing in cash. They will also look for mitigating factors that support a finding of non-willfulness, such as a genuine lack of sophistication, reliance on incorrect professional advice, or a simple one-time mistake. This analysis allows your attorney to advise you on the level of risk you face and to determine which disclosure program, the streamlined procedures or the main voluntary disclosure practice, is the appropriate and safest path for you. This is not a guess. It's a calculated legal opinion based on years of experience with how the IRS views these cases. This initial phase of investigation and assessment can take time, but it is the essential foundation for the entire disclosure. It ensures that the strategy you choose is built on a solid understanding of the facts and a realistic assessment of the risks. In our next chapter, we will discuss the next step in the process: preparing the actual disclosure submission for the IRS. Thank you for listening. This information is a general overview and should not be taken as a substitute for confidential advice from a qualified legal professional. Welcome back. In our last chapter, we walked through the critical initial phase of a tax disclosure engagement, the factual investigation and risk assessment. With that foundation laid, and a strategic decision made on which disclosure path to take, the next step is to meticulously prepare the package for submission to the IRS. Today, we'll explore what goes into building that submission. As we cover these details, please remember our foundational rule. This is a general overview for educational purposes only. It is not a set of instructions or legal advice. The actual preparation of a disclosure submission is a complex and precise task performed by a qualified professional based on the specific requirements of your chosen program and the facts of your case. The contents of the submission package differ significantly depending on whether you are entering the streamlined procedures or the main voluntary disclosure practice, VDP. Preparing a streamlined procedure submission. Let's first look at a typical submission for the streamlined filing compliance procedures, which, as we know, are for non-willful conduct. The goal here is to present a complete and convincing package that clearly demonstrates eligibility. The key components generally include amended or delinquent tax returns. For the most recent 3 years, your professional team will prepare amended tax returns, typically on Form 1040X, or original delinquent returns if none were filed. These returns will include all previously unreported income, whether from foreign or domestic sources. They will be prepared with all required international information returns, such as those for foreign corporations or trusts, attached. Delinquent FBARs. Your team will prepare and electronically file any required report of foreign bank and financial accounts, or FBARs, for the most recent 6 years. These forms detail all of your foreign financial accounts that met the reporting threshold. The certification of non-willfulness. This is the heart of the streamlined submission. The taxpayer must sign a specific IRS form, Form 14654 for the domestic program or Form 14653 for the foreign program. On this form, the taxpayer provides a detailed narrative explaining the facts and circumstances of their case. This narrative, which we discussed previously, is carefully drafted with the help of a professional to provide a clear and persuasive account of why the past non-compliance was not willful. Payment. A check for all the back taxes, interest, and if applicable for the domestic program, the 5% miscellaneous offshore penalty must be included with the submission. Once assembled, this entire package is mailed to a specific IRS processing unit that handles these submissions. Preparing a voluntary disclosure practice, VDP submission. Now let's turn to the more complex process for the VDP, which is for cases involving willful conduct. The process is more interactive and unfolds in stages. The first formal step is gaining preclearance, as we discussed in an earlier chapter. Your attorney submits Form 15257 to IRS Criminal Investigation to ensure you are eligible. Once preclearance is granted, your attorney provides additional information to receive preliminary acceptance. After that, the case is assigned to a civil examiner, and the full disclosure work begins. This involves preparing and submitting a comprehensive package that typically includes a complete set of tax returns. Just like in the streamlined program, your team will prepare correct original or amended tax returns for the disclosure period, which is usually the last 6 years. Supporting documentation. Unlike the streamlined submission, a VDP case requires extensive supporting documentation. This can include detailed financial statements, bank records, and a list of all domestic and foreign accounts and assets. The goal is to provide the IRS examiner with a complete financial picture, a detailed explanatory narrative. The submission will be accompanied by a letter or memorandum from your attorney. This document explains the facts, presents the calculation of the tax and penalties, and advocates for the most favorable resolution under the terms of the VDP. Full cooperation. The submission in a VDP is not a one-time event. It is the beginning of a full examination. Your professional team will manage ongoing communication with the IRS examiner, respond to their questions, and provide any additional information they request. In both scenarios, the watchwords are accuracy and completeness. An incomplete or inaccurate submission can be rejected by the IRS, leading to much worse outcomes. This is why the preparation phase is so meticulous and why it is handled by professionals who understand exactly what the IRS needs to see. In our next chapter, we will discuss what happens after the package is sent, the IRS review process, and the path to final resolution. Thank you for listening. This has been a general description of the submission process. and should not be considered a guide for self-preparation. Always rely on the expertise of a qualified professional. Welcome back. In our previous chapter, we detailed the meticulous process of preparing and building the disclosure package for the IRS. But sending that package is not the end of the journey. It's the beginning of the next phase. Today, we'll explore what happens after the submission, the IRS review and resolution process. As we walk through these post-submission steps, we must reinforce our guiding principle. This is a general overview for educational purposes. It is not legal or tax advice. The timeline, level of scrutiny, and outcome of any IRS review are dependent on the specific facts of the case, the program used, and the IRS's own internal procedures and workload. The experience of a taxpayer who filed under the streamlined procedures is typically very different from one who entered the main voluntary disclosure practice. The streamlined procedure review. After a complete streamlined submission is mailed, the next phase is primarily a waiting period. The package is sent to a dedicated IRS service center where it is reviewed for completeness. What is the IRS looking for? Initially, they are checking to see if all the required components are present. The correct number of tax returns and FARs, the signed certification of non-willfulness, and the full payment of tax, interest, and any applicable penalty. If the submission is deemed complete and the narrative of non-willfulness is facially plausible, the process is often quiet. The IRS will process the amended tax returns and cash the check. It's important to understand that the IRS does not typically send an acceptance letter or formal approval for a streamlined submission. In most cases, no news is good news. The successful conclusion is often marked simply by the taxpayer's check being cashed and seeing the amended returns reflected on their IRS account transcript. However, a streamlined submission is not a guarantee against an audit. The IRS clearly states that these returns can be selected for a full examination under the same audit selection criteria as any other tax return. If an audit is initiated, the IRS will scrutinize the taxpayer's claim of non-willfulness. If they find evidence that the conduct was actually willful, they can revoke the benefits of the streamlined program and assess much more severe penalties. The Voluntary Disclosure Practice (VDP) examination. The path for a VDP case is far more interactive and structured. As we've discussed, submitting the initial application and gaining preliminary acceptance is just the first step. The real work begins when the case is assigned to an IRS civil examiner. The examiner will contact the taxpayer's attorney to formally begin the civil examination of the 6-year disclosure period. This process is, in essence, a comprehensive audit. The examiner will review the submitted tax returns and supporting documents in detail. They will likely issue information document requests, or IDRs, asking for additional records, clarifications, and explanations. The taxpayer's attorney will manage all communications with the examiner, providing the requested information and advocating on the taxpayer's behalf. The process involves a thorough verification of the unreported income and a negotiation over the final calculation of tax, interest, and penalties. The goal is to reach a mutual agreement on all aspects of the disclosure. Once the taxpayer and the IRS examiner agree on the final figures and terms, the case is formally closed. This is typically documented in one of two ways. A closing letter. The IRS may issue a letter stating that the examination is complete and the case is closed. A formal closing agreement, Form 906 in many VDP cases. The resolution is memorialized in a Form 906 closing agreement. This is a formal, binding contract between the taxpayer and the IRS that conclusively settles the tax liabilities and penalties for the years covered in the disclosure. This agreement provides the highest level of certainty and finality. Successfully completing the VDP and receiving a closing letter or agreement is the ultimate goal, providing closure and assurance that the matter is resolved with the IRS. In our next chapter, we will discuss life after disclosure, what it means to be fully compliant, and how to maintain that status going forward. Thank you for listening. Please remember that this description of IRS procedures is for informational purposes only, and is not a substitute for the guidance of a qualified professional in an active case. Welcome back. Over our last 11 chapters, we have journeyed through the complex landscape of U.S. voluntary disclosure programs, from the moment of realization to the final resolution with the IRS. Successfully completing a disclosure is a monumental achievement. It closes a stressful chapter and provides a fresh start. But what comes next? Today, we discuss life after disclosure and the essential practices for maintaining your newfound compliance. As always, this discussion is for general educational purposes. It is not tax or financial advice. The best way to maintain compliance is to continue working with a qualified tax professional who can provide guidance based on your ongoing financial situation. Successfully completing a disclosure is not a one-time fix. It is a commitment to a new standard of diligence. The IRS expects taxpayers who have come through these programs to be fully compliant in all future years. Here are the key pillars of maintaining that compliance. Pillar 1. Timely and accurate filing, every year. This is the most fundamental requirement. You must file your annual U.S. income tax return, typically Form 1040, on time every year. If you need more time, you must file a proper extension. Your annual tax return must be complete and accurate, reporting all of your worldwide income, from all sources. There is no longer any room for error or omission. For those with foreign financial assets, this also means diligently filing all required international information returns. The most common of these is the Report of Foreign Bank and Financial Accounts, or FBR, which must be filed annually if your foreign account balances exceed the reporting threshold. Other forms may be required for foreign pensions, inheritances, or interests in foreign businesses. Missing one of these deadlines can create a new compliance problem. Pillar 2. Impeccable record keeping. Good habits are the foundation of good compliance. After going through a disclosure, you understand the importance of documentation. Going forward, you should maintain meticulous records for all financial matters. This means keeping all of your financial statements, bank, brokerage, and mutual fund statements, both domestic and foreign, tracking your basis in assets. For any property, stocks, or other investments, you must have records showing what you paid for them. This is crucial for correctly calculating gains or losses when you sell them. Organizing your records. Whether you use digital folders, cloud storage, or a physical filing cabinet, create a system that is organized and easy to navigate. You should be able to quickly locate supporting documents for any item of income or deduction on your tax return. The general IRS rule is to keep records for at least 3 years from the date you file your return. However, for records related to property and other long-term assets, you should keep them for as long as you own the asset, plus at least 3 years after you sell it. Pillar 3. Proactive communication with your tax advisor. Your relationship with your tax professional should not be a once-a-year event. Think of them as your ongoing compliance partner. You should proactively inform them of any significant financial changes in your life before the end of the tax year. Events that warrant a discussion with your advisor include receiving a large gift or inheritance, especially from a foreign source, opening or closing any new financial accounts, particularly overseas, selling a major asset, like a home or a large stock position, starting a new business, or changing the structure of an existing one. This proactive approach allows your advisor to help you plan accordingly and ensure there are no surprises at tax time. It transforms tax preparation from a reactive task to a proactive strategy. In essence, life after disclosure is about vigilance. It's about applying the hard-won lessons of the past to build a future of consistent, unquestionable compliance. By filing accurately, keeping excellent records, and maintaining an open dialogue with your tax professional, you can ensure that the peace of mind you gain through the disclosure process lasts a lifetime. In our next chapter, we will address some frequently asked questions about the disclosure process. Thank you for listening. This has been a general guide to best practices for future compliance, and should not be taken as a substitute for personalized professional tax advice. Welcome back. Throughout this series, we have covered the U.S. voluntary disclosure landscape in detail, from the major programs to the intricate processes involved. This journey often sparks specific questions. In this chapter, we're going to address some of the most frequently asked questions about voluntary disclosures. As we go through these questions and answers, please remember that this information is for educational purposes only and is not legal or tax advice. The answers are general in nature, and the application to any specific case depends entirely on its unique facts and circumstances. Always consult a qualified professional for advice. Question 1. How far back do I need to go? What is the disclosure period? This is a very common question. The look-back period depends on the program. For the streamlined filing compliance procedures, the period is generally fixed. It requires filing or amending the 3 most recent past due tax returns and filing delinquent FBARs for the 6 most recent years. For the main voluntary disclosure practice, VDP, the period is generally longer. The IRS policy typically requires amended tax returns for at least the 6 most recent years. However, the examiner has the discretion to expand that period if the circumstances warrant it. The goal is to cover the entire period of noncompliance. Question 2. What happens if I come forward and the IRS rejects my submission? This is a significant concern. If a streamlined submission is rejected, perhaps because the IRS finds the non-willful narrative unconvincing or the package is incomplete, the taxpayer is in a difficult position. The IRS will have their amended returns, which admit to additional income, but the taxpayer will not receive the penalty protection of the program. They could then be subject to a full audit and all applicable penalties. This underscores the importance of submitting a complete and well-supported package from the start. In the VDP, the process is different. The pre-clearance and preliminary acceptance steps are designed to vet eligibility upfront. Rejection is less common after preliminary acceptance, provided the taxpayer cooperates fully and provides all required information during the subsequent examination. Question 3. What if the person who was non-compliant has passed away? Can an estate still make a voluntary disclosure? Yes, this situation is quite common. An executor or personal representative of an estate can make a voluntary disclosure on behalf of a deceased individual. If the executor discovers that the decedent had undisclosed accounts or unreported income, they may use one of the disclosure programs to rectify the situation. This is often necessary to properly settle the estate, pay all of its tax liabilities, and distribute the remaining assets to the heirs in a compliant manner. The analysis of willful versus non-willful conduct would be based on the decedent's actions during their lifetime. Question 4. We have discussed the federal IRS programs. What about state taxes? This is a critical and excellent question. The IRS programs we've discussed resolve your federal tax liability only. They do not resolve your state tax issues. Most states with an income tax have their own, separate voluntary disclosure programs or policies. If you have unreported income that was also subject to state tax, you will likely need to make a separate disclosure to the relevant state's Department of Revenue. The procedures, look-back periods, and penalty structures for state programs vary widely. It is a completely separate process that must be handled in parallel with the federal disclosure. Question 5. Can I do this anonymously? Generally, no. While the initial pre-clearance request in the VDP can sometimes be made by an attorney on an anonymous basis to check for eligibility, the disclosure itself requires the taxpayer to be fully identified. To come back into compliance, you must file accurate returns under your own name and social security number. The purpose of these programs is to bring taxpayers back into the system, which requires full transparency. We hope these answers have clarified some common points of uncertainty. In our next chapter, we will discuss the global context of tax compliance and why voluntary disclosure has become more important than ever. Thank you for listening. This information is general in nature. Please consult a professional for advice on your specific situation. Welcome back. In our journey through the world of U.S. tax disclosure, we focus primarily on the programs and procedures within the IRS. But the story is much bigger than that. The entire landscape of international finance and tax compliance has undergone a seismic shift in the last decade. Today, we'll explore the global context and understand why the concept of hiding offshore is rapidly becoming a relic of the past. As we discuss these international agreements, please remember this is a high-level overview for educational purposes. It is not legal or investment advice. The global financial system is complex, and this information is intended to provide a general understanding of the current environment. The end of bank secrecy. For decades, the idea of a secret, numbered Swiss bank account was a fixture in popular culture, and, to some extent, in reality, bank secrecy was a shield that made it difficult for tax authorities like the IRS to learn about their citizens' offshore assets. That shield has been systematically dismantled. The world has moved decisively toward transparency. Two landmark developments are at the heart of this transformation: FATCA and the CRS. FATCA, the Foreign Account Tax Compliance Act. First, let's talk about FATCA. Enacted by the United States in 2010, this law was a game changer. FATCA requires foreign financial institutions, banks, brokerage houses, and investment funds all over the world to report information about financial accounts held by U.S. taxpayers to the IRS. How does it work? The U.S. entered into agreements with more than 100 other countries. Under these agreements, a bank in, for example, Germany, Switzerland, or Singapore must review its accounts to identify U.S. persons. It then reports information on those accounts, including the account holder's name, address, U.S. taxpayer identification number, account balance, and gross income, to its own government's tax authority. That authority then automatically transmits the information to the IRS. If a foreign bank refuses to comply, it faces a steep 30% withholding tax on certain U.S. source payments it receives. This powerful incentive has resulted in near-universal compliance. The result is that the IRS now receives a massive, steady stream of data about the foreign financial activities of U.S. taxpayers directly from the source. CRS, the Common Reporting Standard. The rest of the world saw the power of FATCA and decided to create a global version. Developed by the Organization for Economic Cooperation and Development (OECD), the Common Reporting Standard, or CRS, is essentially a multilateral version of FATCA. Under CRS, over 100 participating countries automatically exchange financial account information with each other every year. For example, if a resident of France has a bank account in the Cayman Islands, the Cayman Islands Bank will report that account information to its government, which then automatically sends it to the French tax authorities. While the U.S. is not a formal participant in CRS, it achieves a similar result through its own network of FATCA agreements. The takeaway is the same. Information about who owns what and where is now being shared between countries on an unprecedented scale. The impact? Nowhere left to hide. The combined effect of FATCA and CRS is that the world is now covered by a web of information sharing agreements. The digital age allows for the seamless transfer of vast amounts of data. This means it is no longer a question of if the IRS will find out about an undisclosed foreign account, but when. This new era of transparency is precisely why the voluntary disclosure programs we've been discussing are so critical. They provide a final opportunity for taxpayers to address past noncompliance proactively, on their own terms, before the inevitable discovery by the IRS through this global data exchange. In our final chapter, we will conclude our series with a summary of the key takeaways and some final thoughts. Thank you for listening. This information is a general overview of a complex global topic. For advice on your specific situation, please consult a qualified professional. Welcome back for the final chapter of our comprehensive series on U.S. voluntary tax disclosure programs. Over the last 14 chapters, we have navigated a complex and often intimidating world. We've defined the programs, distinguished between willful and non-willful conduct, compared the different pathways, and explored the global shift toward financial transparency. Today, we bring our journey to a close by summarizing the key takeaways and reflecting on the ultimate goal of this entire process: peace of mind. Before we conclude, we offer our final and most important reminder. This entire series has been for educational and informational purposes only. It is not, and has never been, a substitute for confidential legal and tax advice from a qualified, independent professional who can analyze your unique situation. Key takeaways from our journey. As we look back on our series, several core truths stand out. First, the world has changed. The era of financial secrecy is over. Through global initiatives like FATCA and the Common Reporting Standard, information now flows freely between countries. The question is no longer if the IRS will discover noncompliance, but when. This new reality makes proactive solutions more critical than ever. Second, acknowledgement is the first step. The most dangerous decision is indecision. Tax problems do not solve themselves. Acknowledging an issue and resolving to address it is the first and most powerful step you can take to regain control of your financial life. Third, there is a path for everyone. The IRS has created a structured framework to help taxpayers come back into compliance. Whether your past conduct was non-willful, leading you to the streamlined procedures, or potentially willful, pointing toward the main voluntary disclosure practice, a formal pathway exists. You are not the first person to face this challenge, and a process is in place to guide you. Fourth, professional guidance is non-negotiable. This is not a do-it-yourself project. Navigating this landscape requires the expertise of a specialist, particularly a tax attorney, who can provide the protection of attorney-client privilege. Investing in the right professional is an investment in a successful outcome. Fifth, honesty and cooperation are paramount. All of these programs are built on the foundation of the taxpayer coming forward truthfully and cooperating fully. The goal is to provide a complete and accurate picture of your past finances, and to pay what you owe. In return, the system offers a resolution with predictable penalties and, most importantly, a path to avoid the most severe consequences. The ultimate goal: certainty and closure. Why would someone undertake this demanding and often expensive process? The answer is simple. It is to exchange uncertainty for certainty. It is to trade the constant, low-level anxiety of a potential audit or investigation for the finality of a formal resolution. Completing a voluntary disclosure allows you to close a difficult chapter of your life and move forward with confidence. It allows you to plan for your future, manage your assets, and provide for your family without a shadow of past non-compliance hanging over you. It brings you back into the system as a taxpayer in good standing. This is the true definition of financial peace of mind. Thank you for joining us on this extensive journey. We hope this series has demystified the topic of voluntary disclosure and provided you with a clear, educational framework for understanding the options available. We wish you clarity and success on your path to full compliance.
Disclaimer: this video is for informational and educational purposes only and should not be considered professional legal, financial, or tax advice. I am not a certified public accountant, CPA, or a tax attorney. You should consult with a qualified professional for advice tailored to your individual situation. Tax laws are complex and subject to change. The creator of this video or the channel will not be held liable for any actions taken based on the information provided.